non-violent offender, don't need to get into it. So the Missouri revised statutes, they had an overhaul. We had an overhaul of the Missouri Criminal Code back in 2017. However, the criminal non-support statute pretty much stayed the same. So for the criminal non-support statute, you're looking at the Missouri revised statute, and it is section 568.040. And basically, a parent commits the offense of non-support if such parent knowingly fails to provide adequate support which such parent is legally obligated to provide for his or her child or stepchild who is not otherwise emancipated by operation of the law. So what exactly does all that mean? That basically means that if you have a child or a stepchild, or you are legally obligated to this child by other legal processes, then you have to provide that child adequate support. And if you don't provide that child adequate support without good cause, then you gonna get charged with criminal non-support. So when we look at this statute, we can go a little further, and there's a particular defense for the statute. There's a defense for the statute that specifically reads in subsection 3, the inability to provide support for good cause shall be an affirmative defense under this section. Now, if a defendant raises such an affirmative defense, that defendant has the burden of proving the defense by a preponderance of the evidence. So if you and your attorney decide to have a trial, whether it's a jury trial or a bench trial, if you and your attorney decide to have a trial because you cannot pay your child support, you have not paid your child support for good cause, then you got to have a trial. You have to assert good cause, and you have to prove that you haven't paid your child support for good cause. Like, you have that burden. Now, generally in a criminal prosecution, everybody understands that the prosecutor has those famous words, that burden that's famous, proof beyond a reasonable doubt. But when you inject the defense of good cause, then the burden shifts, and you have to show by a preponderance of the evidence that you had a good reason why you haven't been paying your child support. Now, what's the range of punishment for a person who has failed to pay his or her child support? Well, according to the law, the range of punishment is either a Class A misdemeanor or a Class E felony. So you can get a felony for failing to pay your child support. So for a Class A misdemeanor, the range of punishment is up to a year in the county jail. For a Class E felony, the range of punishment is up to 4 years in the Missouri Division of Adult Institution or in prison. So you can get up to 4 years in prison if you fail to pay your child support. So failing to pay your child support, getting behind on your child support, That has so many different implications. Not only can you get charged criminally, but the collateral consequences of not paying your child support starts trickling down, and you can lose your license. You can lose your driver's license, which in turn will cause you to get a driving while revoked or suspended because you don't have your license. So now you got to pay more money for that. Then you can sit up there and get all these tickets, go to jail, lose your job if you have a job. There are so many different collateral consequences that are associated with failing to pay your child support. But let's get back on topic. So basically, there are 4 elements that has to be proven in order for a conviction to stand with a non-support, in order for you to be found guilty of either the Class A misdemeanor where you are facing up to a year in jail, or the Class E felony where you're facing up to 4 years in prison. We talked about you knowingly failing to provide. A parent knowingly fails to provide. Well, what is knowing? When people try to figure out, well, what does it mean that you knowingly failed to provide? Well, let's say you were married, and let's say there was a child born while you guys were married, and you say the father, because they say mama's baby, daddy's maybe. So let's say the father signed the birth certificate but wasn't really sure if the baby was his, and then they get a divorce and he wants a paternity test. Well, that's not gonna really fly if the father's been taking care of this child for a great time. So you know that there's a child. You should have had that paternity test done then and there if you thought your wife or your spouse or your significant other was doing something, but you've been taking care of this child. Now y'all divorced or separated and you want to get a paternity test. The court said, no. You're not going to get away with that. You're going to go ahead and pay for that kid like you've been doing when you were doing whatever you were doing with that mama. So knowing is knowing that you have a legal obligation. It's a legal obligation. You have a legal obligation. That's either your biological child. You've been holding yourself out as that child, but you and the mother were, say, married, or you got with a woman and married her and you adopted her children. So they became your stepchildren. You are obligated for those kids if you decide to leave. And women, you're obligated as well. So if you marry a man and he has a bunch of children and you decide, okay, I can step in this role. I'm going to adopt these children and I'm going to adopt these children legally and I'm going to be there for them. Well, if he decides to leave you, then you're going to be paying child support on those children if you have the ability to. Yes, you are going to be paying child support on those kids, even though they're not yours. They're considered yours legally because you decided to adopt them. Now, remember, you can call in if you have any questions. You can call in at 816-599-6893. 816-599-6893. So what's good cause? Well, good cause is one of the elements, one of the 4 elements. What's good cause? Well, good cause is not saying, I was laid off and I couldn't work. Well, the court dealt with that back in 1994 and in 2008. The appellate court dealt with that in 94 and 2008, where the dude was like, let me see. He said that he had a back problem and oh, but his job closed up, the company closed up, there were all these cutbacks on his employment or his job, and that company went over, so he invested some of his money in another business, and that business didn't really take off. Well, the court was like, I don't care, you're really not producing anything but talk, and we're from the show me state, so you have to really show me why you're not taking care of your child. So that little excuse failed. So then we went to a guy. There was a guy in 2005. He and his lawyer did what they needed to do. They bossed up, and this man said that he couldn't pay his child support because he had a back injury. So not only did he have a back injury, he brought his doctor in to testify about how sick and ill he was. So there you have it. There's good cause. It's not just talking about it. They brought in the doctor. So I believe we have a question.
Yes, Mr. Charles Johnson says, do child support stop once I was incarcerated?
That's a very good question, Mr. Johnson. Under normal circumstances, that would be considered good cause. If an individual is incarcerated, then they're unable to work. However, if the person is incarcerated on a non-violent offense, let's say the person went into custody on a non-support. Let's say a person went to prison for not paying their child support, so they got a 4-year sentence. If that individual who was incarcerated on this non-violent offense, pursuant to section 568040, if the person is able to establish that they have employment, that they are willing to work, they're able to work, then they're supposed to be let out on work release. So, and the only reason why they're supposed to be let out on work release is because that element of good cause shown is no longer met. And since they can work, the money that they get from work release, they're supposed to send over to the child. So good cause is an adequate defense when a person is incarcerated. That's a very good question. Another good defense, besides like actually bringing in your doctor, explaining that you're too ill or too hurt to work, is if you as the defense or the defendant can establish that you have been making in-kind support to your child. So you haven't been going necessarily through the prosecutor's office, because through the prosecutor's office making the payments, or through the state making the payments, but you've been supporting the child in kind. Well, what exactly does that mean? That means that you have not been sending that check in or paying insurance, medical insurance, but you have been buying shoes, buying clothes, buying food, buying beds, buying different things, paying a light bill or whatever that child needs. If you can show with documentation that you have been providing in-kind support to that child, and it's adequate support. It's not just, oh, I bought my baby a pack of diapers, and now the baby's 5 years old and they're coming after you. Like that's inadequate. That's not good enough. But if you can say, well, since this child is 5 years old and I've purchased school supplies, bikes, diapers, wipes, pull-ups, whatever a 5-year-old needs. I don't think they need pull-ups at 5. But if you can document and have documentation of what you've been doing for that child, then that, according to the the Missouri courts, the Missouri Supreme Court is a good defense. It's defensible. We've already talked a little bit about the legal obligation. That basically means you're either biological step, you've adopted, you've gained guardianship, or you have failed to challenge within a sufficient time frame the paternity of the child. Now, let's go to what I like to kind of harp on. According to the Missouri Constitution, Article 1, Section 11, it specifically states, prosecution under criminal non-support statute is not a proceeding to enforce the terms of a divorce decree providing support for minor children, and is not a proceeding seeking imprisonment for a debt. Let me repeat that. Prosecution under criminal non-support statute is not a proceeding to enforce the terms of a divorce decree providing support for minor children, and is not a proceeding seeking imprisonment for a debt. So, what I don't want people to think is that Armida is an advocate for men and women to run around and not pay their child support. That is absolutely false. I am not an advocate. I do not condone that. That is unfortunate for the child, and in turn, unfortunate for you if you're doing that, and you're going to get whatever you're going to get, because our God is an awesome God and knows what you're doing. However, what I am saying is, for a person to sit over there at that Jackson County jail because he or she has failed to pay their child support is a violation of the Missouri Constitution, Article 1, Section 11. Not only is it a violation of Article 1, Section 11, it's a violation of our human dignity. Right now in Jackson County, just about every week on the news, you're hearing something about the Jackson County Jail and how pathetic it is, how it's overcrowded, how it's not run adequately, how the people are not getting food and toiletries and treatment. And so we want to overcrowd the Jackson County Jail with non-violent offenders, with people who are charged with non-support. When I worked for the public defender's office, see, I didn't go into the Reader's Digest version of my curriculum vitae because hopefully everybody knows who I am. But for those of you who don't know who I am, I started out as a public defender in the Kansas City trial office in 2004. And as a Kansas City public defender, working all kind of cases, from murder in the first degree all the way down to these criminal non-supports. I had men and women who were locked up in that Jackson County jail every week when I had to go and fight for their release on a violation docket because they can't pay their child support. They can't pay that debt every week. I'm not a public defender anymore. I'm in private practice. And now I get to pick and choose the cases that I take on. And one case that I refuse to take is criminal non-support. If a man or a woman comes to me who is charged with criminal non-support, I'm not going to take it. I'm not going to take it. Why? Number one, if you have the money to pay me, you need to be paying for your child. That's number one. That's number one and the only one. If you can pay me, you need to be paying that money that you would pay me to your child. Period, point blank. But I was in court. A few weeks ago, maybe a month ago by now, but this just stuck with me. I'm in court waiting for my client's case to be called. My client was not in custody. She was charged with an assault. So she's not in custody. But in shuffles a guy. He has on his chains and his shackles and his Jackson County orange jumpsuit. And his public defender ran right up to the judge. Judge, please let my client out of custody. My client has a job. He's been in custody for 7 days. Judge, please let my client out of custody. If you don't let him out, he's going to lose his job. And the judge denied the request. We have this non-violent person charged with criminal non-support, occupying a bed space when we have men and people out here who are killing these women and children. That is unacceptable. We need to reevaluate who we are putting in the Jackson County jail before we start talking about, oh, let's build another jail. We don't need to build another jail. We need to reevaluate the nonviolent offenders that we are putting in the jail. As a matter of fact, since 2018, so just this year alone, on a monthly average, there are over 300 nonviolent offenders. On a monthly average, 300 nonviolent offenders that are running in and out of the Jackson County Jail. Nonviolent offenders, y'all. You know, I don't know if these homicides that are happening, I believe another one just happened either earlier today or last night. I know one happened a couple of weeks ago down the street from my house, and then literally a week later on the same street, another one happened again. That's 2 in 7 days on the same street. Now, I don't know if the same person or a group of people are running around committing these violent crimes and these homicides. But what I do know is that if we put our effort into incarcerating and catching these violent people, then the nonviolent offenders, we would say they have no place in that Jackson County jail. This community is very important to me. The violence has got to stop. We don't need nonviolent offenders locked up. We need the people who are killing us, who are hurting us, who are running around here with no regard to human life. That's who needs to occupy those beds. Not somebody, not some poor man or some poor woman who can't pay their child support. It's time to do something different, Kansas City and Jackson County. It's time for new leaders, new public servants. I'm Armida Dupree. We've been brought to you by KUAW, Knowledge, Understanding, and Wisdom. We are sponsored by Music and More Foundation. I'd like to thank you all for tuning in. And we will wrap up in a few moments. Thank you. Yeah, you know it's Welcome back to Criminal Law 101 with me, Armita Dupree. We are being brought to you by KUAW and sponsored by Music and More Foundation. You know, we come on the air every fourth Friday of the month at 6 o'clock. And I just like to say thank you for tuning in. For those of you who are live, for those of you who are going to tune in when this is not live. But remember, August 7th is a very important day. I can't tell you who to vote for because other candidates are not here. But what I will tell you is if you exercise your right to vote, then you are exercising your ability to have your voice be heard. It's time for a new generation of public servants. Let's make a move. Let's shift. Let's tell them time's up with this politics as usual because our community is being run down and it's time for us to lift up. Thank you. Come back next month, next August, fourth Friday. I'll see you then. And if you want, you can leave in your comments what you like to hear us talk about with the Criminal Law 101. Have a good weekend, y'all. Bye.
All right. You've been listening to Criminal Law 101 with Armita Dupree. Stay tuned. Our next show starts at 7 p.m. It's the Juice TV and radio show. And we're going to be doing a tribute to Toby Lee. He was the creator of Juice TV radio show. And he passed away a couple of Sundays ago. His funeral is tomorrow. So we're going to have a special show on this evening starting at 7 till 8 p.m. And then we're going to play his old shows from 8 p.m. until midnight. So tune in at 7 p.m. for a memorial and tribute show to Toby Lee, the creator of Juice TV and radio, who passed away just 2 weeks ago. Thank you.